And I'm looking at your criminal history. Your criminal history is outrageous for a person your age. Do you deserve 16 years?
No, ma'am.
Oh, why not?
We also have included motions for speedy trial in both cases.
All right. So do you still want to assert your right to a speedy trial, counsel? Because your client is saying that he prefers to come back on March 18th.
And Norma, check.
Okay, so let me finish speaking.
Okay.
All right, everybody, take a breath. Calm down. Let me finish speaking.
Plate bearing the word traveler on it. During this.
Hold on. Before we dive into the sentence, we're seeing two very different cases spliced together here. Case 1 is a sentencing hearing for aggravated robbery, which carries up to 99 years. Case 2, coming up later, is about amending bond conditions and a speedy trial motion. That jump at the beginning, that's the judge immediately setting the tone. She has seen the defendant's record, and she is not playing around. The defense trying for a speedy trial motion later suggests they want to force the state's hand. But as we'll see, the judge is a killer counter-move.
Stop. The defendant refused to provide.
Traveler.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point.
I require $1,400, and I will be charging the court $1,400 for my time.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. This will be set for sentencing on December 7th. We'll schedule PSI. And even though he's not applying for probation, I am going to schedule a TAP evaluation that'll give me some idea.
Thank you.
Is there anything else, counsel?
No, Your Honor.
All right. We're going to come back on December 7th. I'll make a decision on your sentence based upon any other evidence that's presented to me in the TAP evaluation in the PSI. Do you understand?
Yes, ma'am.
All right. Thank you. The defendant entered a plea on October 23rd of guilty to the offense of aggravated robbery. According to the plea bargain agreement, there are no applications and punishment is be assessed at a cap of 16 years in the prison. And there are several cases that are being taken into consideration. Have both parties had a chance to review the PSI report?
We have, Your Honor. We have, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense, any objections to the PSI report?
No, Your Honor.
All right, defense, I note in the PSI report things that your client has said, which is that he has no idea where these charges came from. And specifically, what he says in the PSI report, and the reason why I want this on the record is because I want to make sure that your client actually wishes to continue with this plea. What he said.
Okay, big red flag moment. The judge just dropped a bomb about the pre-sentence investigation, PSI report. This report is everything. It includes a defendant's background, interviews with victims, and his own statements. The fact that the defendant told the PSI writer he has no idea where these charges came from while pleading guilty is a massive risk. It shows a complete lack of remorse, which judges hate, and makes the judge question the validity of his guilty plea. This is a judge ensuring she is covered on the record. Did he plead guilty, or is he actually claiming innocence?
As to the instant offense, the defendant stated he was at his home on this date when the victim reached out to him and wanted to hang out. He stated that he agreed to go over to his home. He stated that he got an Uber to the victim's home and a friend ended up going with him. He stated while at the victim's home, he offered him some clothes and money. He stated that the victim knew he was struggling and offered to help him. He stated that the victim even allowed him to wear his jewelry. He stated that he left the location and went to a nearby park. He stated that he did not end up going back home. He stated that the victim sent his friend some money so that they could Uber back home. He stated that later that day, the victim contacted him and told him that he needed his items back. He stated that he ignored the victim. He stated that he later found out that he had a warrant for this case when he attempted to make a payment to his bondsman for another case he has pending. He stated that he called the victim and confronted him about the allegations. He stated that he was later arrested for the instant offense. The defendant denies the allegations of him using or having a gun, but did admit to keeping the victim's clothes and other items.
And that is correct. It is in the PSI report, and I'll ask the court to also focus on page 5 of the victim impact statement. So, Judge, there was multiple felony cases that were plea bargained in this case that the state took into consideration and dismissed, and that's why we went forward with this case. So, my client has stated that he doesn't want to go forward with this case. There were many concessions made by the state of Texas on this particular defendant, so that's why we want to go forward.
All right, Mr. Ramos, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
And Nicholas Ray Ramos.
All right, Mr. Ramos, do you wish to go forward with this plea?
Yes, Your Honor.
All right. You do not want a jury trial?
No, ma'am.
All right.
Whoa, wait. The defendant just described a full story where the victim helped him, giving him clothes, money, and jewelry, only for the defendant to keep the items and ignore the victim's calls. Then he denied the gun but admitted keeping the stolen property. The defense attorney's Hail Mary is to remind the court they dismissed multiple felony cases for this plea. They're basically saying, "Judge, we cut a deal and he's sticking to it." But the judge just got a glimpse into the defendant's moral compass. This is turning into a battle for the high end of the 16-year cap.
Thank you.
All right. Are there any witnesses from either side?
No, Your Honor, we were informed that the witnesses made PSI statements that were contained in the PSI.
All right, then any witnesses defense?
No, Your Honor.
All right, then the court will hear argument. State.
Judge, there are numerous cases that have been taken into consideration in order to reach this case, or in order to reach this plea agreement. I know that the defendant is young, pretty early in his life, but in that short amount of time that he's been an adult, he has racked up numerous arrests and various cases, again, were taken into consideration. I think that it's the nature of those other charges and the fact that even while on probation or deferred on those charges, he still was picking up other cases. My understanding is that he was on probation when this all happened. So we would ask that you hit the cap, Judge, of 16 years.
All right, defense.
Your Honor, obviously my client is very young, and he'll admit that he has made some serious mistakes. He has a young daughter now that he has not even had a chance to see at this point. One of the things I want the court to consider, and when the court pronounced a sentence in this case, the co-defendant in this case was sentenced to 8 years TDC. And we think that's appropriate given the circumstances. Yes, my client was involved and I shouldn't say was involved, but has been charged with other cases. The district attorney's office made a commitment to dismiss those cases, and they have done so. Judge, with respect to this particular case, the complainant's father has stated that the victim in this case was not hurt, but he did not get his property back. So in light of that, his age, we'd ask the court to consider an 8-year sentence, which is what the court saw fit when the court pronounced sentence on the co-defendant in this case.
And Judge, if I may, the co-defendant was sentenced in the 187. There is a stark difference between that co-defendant and this defendant. That co-defendant did not have nearly as many cases that were being taken into consideration. So that was something that drastically changed what was happening in that situation versus this situation.
All right. And just so everyone knows, and I know both attorneys know, I look at cases individually. So, Mr. Ramos, is there anything you want to say?
Yes, ma'am. I've been incarcerated 8 months. I know I did what's wrong. No. Whatever I did, I know it caused me to come in this courtroom today.
Sorry, I'm having a hard time hearing.
My bad. I know whatever I did caused me to come in this courtroom today, and I know it caused a lot of harm to different people's families and stuff. But I had more than enough time to think about what I've done. I just try to get back home to my little girl. That's it.
All right. So how old is your child?
2 months and a week and a half.
So why didn't you think about this before?
And here's the Judge Dredd moment we've been waiting for. She immediately zeroes in on the most dramatic and common excuse: the new baby. The question, why didn't you think about this beforehand, isn't just a burn. It's the core moral conflict of the entire hearing. The judge is challenging his state of remorse, suggesting his priorities are deeply flawed. Audience, how would you respond to the judge in this situation? Do you think the new baby is a mitigating factor, or does it make the crime worse? Let me know in the comments.
No,
I'm sorry?
I have a comment on it, Your Honor.
Why are you out committing crime? I don't understand. And I'm asking you these questions because I'm trying to figure out what will be the appropriate sentence for you. The state and the defense will tell you. State and defense, they come up with their agreements. This is their agreement, that I can sentence you up to 16 years in prison. So I'm asking you these questions so I can make a decision on what to sentence you to. And that's a lot of time, because the range of punishment for this offense is, because they've capped it at 16, is 5 to 16 years. So that's what I can sentence you to. So I'm trying to figure out what is your thought process and why you are out here committing crimes and violent crimes. I mean, did you wake up one day? I always think of people who appear before me when they were in elementary school. Did they wake up one day and decide, hey, I want to be a criminal?
Right.
So I'm trying to figure out, where did you go in your life that you decide, hey, I want to be a criminal? And I'm looking at your criminal history. Your criminal history is outrageous for a person your age. And I don't know if the misdemeanor, when you were placed on deferred adjudication, in that case, I don't know if something could have put you on the right path from there. We have the burglary of vehicles, not vehicle. There's a lot going on. And then there's an assault bodily injury case that's pending in County Court 15. So I'm trying to figure out, what is your issue?
I guess I had a bad crowd around me. I ain't really had nothing for a little while. I have no structure.
Oh, don't come to me with the structure thing, because there are a lot of people who don't have structure. And when you mentioned the bad crowd, I guarantee you the person who got 8 years, when they said they were running around with a bad crowd, they were talking about you.
Yeah.
So since you brought up structure, what do you mean you don't have structure?
I had nowhere to go. I had no financial support.
How about getting a job?
I had nothing to get a job. I was old enough to get a job, and I had more than another chance to get a job, but I have no ID. I have no social security, none. I had lost all that.
So why didn't you have an ID?
I lost it while I moved out the house a little while ago.
So why are you moving out the house? Don't want to follow people's rules?
Yes, ma'am.
So your lack of structure is because of you. It appears that somebody was trying to give you structure. And then in the PSI report, it says that you were going back home. So what home was this you were going to?
I was really staying with my friends and my girl at the time.
Where? With who? Who's all in the house? Her parents?
Yeah, me, my girl, her mom, her little sister, her older sister, and her brother.
All right. I still don't understand why parents allow children to live in their home and play house.
I don't understand why they would either, but I guess it was, I don't know, I guess it was because I was with her daughter and we were having a baby.
Okay, sorry. You need to put the mask down.
I don't know why they would let me stay at the house either, but I don't know. I don't know. I was with her for a little while, and I guess I had a good relationship with her family.
But you still haven't explained to me why you're going out committing a bunch of crimes, because you were placed on deferred adjudication. And I will tell you now, whenever you're placed on deferred adjudication now, it's different from when I first started practicing. Back then, it was you're on your own. But usually they will say, oh, you don't have an ID? Let us help you get your identification. Oh, you don't have this? Let us help you get this. So your response to not having your identification or having anything was to throw up your hands and start committing.
This is a judge expertly dismantling every single one of his excuses. Bad crowd. She turned it back on him. He was the bad crowd for the co-defendant who got a lighter sentence. No ID/no job. She pointed out that probation officers are required to help with that now. So the ID excuse is a failure of his own follow-through, not the system. She is leaving him with zero mitigating factors by showing his issues are personal responsibility issues, not situational ones.
Crimes. So I'm trying to figure out what to do with you. Do you deserve 16 years?
No, ma'am.
Oh, why not? And the question I'm asking you, your attorney will tell you, I ask a lot of people these questions. And so I want to see where your head is at. What do you think you deserve for committing an aggravated robbery, stealing from somebody who was trying to help you by giving you clothes, by giving you food, and according to you, paying for your Uber to and from their house?
Years.
Oh, okay. You're saying 8 years. Because I'm not even going to interfere with attorney-client. So why do you think you deserve 8 years for pulling a weapon on somebody and taking their items? Let me put you into this situation so you can understand better. Do you love your girlfriend?
Yes, ma'am.
Do you love your daughter?
Yes, ma'am.
Let's say your girlfriend and daughter are at their home minding their business, and one of her girlfriends comes over because she has a baby and she needs milk and all of the, maybe some clothes for her baby. And your girlfriend say, oh, my daughter is now 2 months old. I have some 1-month-old clothes. Here you go. Here's some clothing. Here's some money for you. And then that friend's like, oh, thank you. And then that friend pulls a gun on your girlfriend with your baby there and takes her items. What do you think that person should deserve? And that's an aggravated robbery that she would have just committed. And the range of punishment for that is 5 to 99 years or life in prison. What do you think that person deserves? Not talking about you, talking about the fact scenario where your girlfriend's best friend comes over, pulls a gun on her and takes items. What do you think she deserves?
The sentence.
I'm sorry, what?
More than 8 years.
More than 8 years? Well, why? Because you know what? Maybe she doesn't have her ID. Maybe she's not able to get a job. Why shouldn't she just get 8 years? And you know what? Maybe she's running around with the wrong crowd. Why shouldn't she get 8 years? Because she's with a bad crowd. She doesn't have her ID. She doesn't have a place to stay. She has a baby to take care of. So why shouldn't she get 8 years for pulling a gun on somebody and taking their items after they tried to help her? Because she's just running around with the bad crowd. She just doesn't have her ID and she just needs items for her baby. So why shouldn't she be allowed to just pull a gun on your girlfriend, take items that she wants, and then come before court and say, please just give me 8 years, or please just give me deferred adjudication because I'm running around with a bad crowd. I don't have my ID. I don't have my social security card, and I need money, and I don't have a job. You don't want that person to have 8 years because they pulled a gun on somebody you care about, right?
Yes, ma'am.
That's what you've done in this case. You pulled a gun on somebody who was trying to help you out, and they have family members that care about them. So, do you still think you deserve 8 years? I mean, you may want it, but do you deserve it?
No, ma'am.
All right. So what do you think you deserve?
Your Honor, may I on his behalf?
No, just 1 second. I want to know, what do you think you deserve? Honestly, look into your heart. What do you think you deserve for what you did to a friend who was helping you out?
12,
I'm sorry,
10 or 12.
why not the full 16? Because it's just too much time? Is it because it's just too much time for you and you can't imagine doing 16 years? All right, any questions?
I don't have questions, Your Honor. I would just ask the court to consider somewhere in the 8 to 10 year range. Judge, my client did not have family structure growing up. I think that's what he was trying to tell you. He couldn't even remember his mother's last name. His father didn't give him much support. He was out on the streets by the time he was 17. He's 19 now. So when he committed this offense, he was basically homeless. He didn't have any place to go. And I would suggest that's probably why he committed these offenses. I'm not saying it's right or wrong. I mean, it's definitely wrong. Okay? But he is very young. He's not the smartest kid in the world. And I think he dropped out of school in 7th grade.
All right, why are you dropping out of school? When did you drop out of school?
7.
Why? Mask down so I can hear.
I don't know. I had gone to a fight in 7th grade, and I just never went back to school because I was going to alternative. I didn't feel like going back to alternative.
All right, they sent you to alternative school because there were issues at what we would call regular school. So that's, people just don't go to alternative school because, hey, let's send them to alternative school. Usually there's some incident that has happened at regular school and you get sent to alternative school, be it for behavior or something else.
And it was a fight.
So it was a fight. So you got sent to alternative school. And when you're sent to alternative school, it's not forever. So you decided not to go back to school. Why not? Do you know, in Africa, I watch a lot of TV and watch a lot of documentaries. There are students in Africa who walk to school. They don't have any shoes. They don't have any desk. They sit on the floor with one sheet of paper. They don't have uniforms because they need to pay for their uniforms to go to school. And they sit on the floor because they don't have any desks for them. There's actually an organization called Kids in Need of Desks. And what ends up happening is people give money to that organization. So they actually make desks for the children. And now they've started making shoes for the children. And if you see the smiles on their faces just for the little things. And then here in America, you can go to school for free. And you drop out at 7th grade and commit a bunch of crimes. And now you're bringing a 2-month-old into the world and you have no way to support that 2-month-old other than being a criminal and stealing items. That's a problem. You understand?
Yes, ma'am.
All right. Anything else from the state?
No, Your Honor.
All right. This is what the court is going to do. Court is finding you guilty. Court has already previously taken in consideration the cases that were listed in the agreement. This is going to run concurrent with County Court Cause number 691548, 691549, 694250. Mr. Ramos, I've read the PSI with a fine-tooth comb, read the offense with a fine-tooth comb, took into consideration the things that the complainant said in the PSI. And I'm taking in consideration your age. I hope that you can get your life together. There's a $500 restitution to Beatrice Gonzalez, which was the deductible. Is there going to be any objection to the court ordering that?
No, Your Honor.
No, Your Honor.
All right, there's to be restitution to Beatrice, Beatrice. Excuse me, if y'all cannot talk on the back row behind the court reporter, if you need to speak, just move to the other end. Gonzalez, Gonzalez. And the amount of $500. I'm just checking to make sure there's no restitution to anyone else. Is that the only restitution state in the defense?
Money-wise, Your Honor, there was some property that was taken from the victim in this case that was never given back clothing and things of that sort of nature.
All right. They didn't list an amount for restitution for that.
They didn't, Judge.
All right. All right. Court is going to sentence you.
The verdict is in 12 years. The judge went right into the middle ground, splitting the difference between the defense's 8-year request and the state's 16-year cap. Crucially, the judge explains her rationale to prevent him from becoming fully institutionalized, essentially giving him an opportunity for rehabilitation without the full weight of the maximum sentence. She didn't give him what he wanted, 8 years, but she saved him from the full wrath of the state, 16 years. A powerful lesson in accountability and mercy.
To 12 years in the prison. Give you credit for any time served. I'll ask for the therapeutic community. Is there anything else with regards to sentencing?
No, Your Honor.
All right. And I want to let you know the reason why I'm giving you the 12 years instead of the full 16 is because, one, I don't want you to 100% become institutionalized, because when people go to prison, it's a crapshoot whether or not they're going to be rehabilitated. And when you go to prison at your age, there are going to be a lot of influences at the prison that are not going to be good for you. And I would love it if people would go to prison and they could just do their time and not be bothered by anyone else. But you may end up being bothered by other people. You're going to have to keep your nose down. Do not become institutionalized. And while you're there, you're going to have to start thinking more about what got you there. And what got you there is not the fact that you don't have your ID or you're running around with the bad crowd, because you're part of the bad crowd. Do you understand? Do you understand? Showing you what's in the Idaho trial for the certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Sign.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you need to speak to an attorney. And I don't know if I said it previously, but there's an affirmative finding of deadly weapon. And I'm going to do no contact, no in-person contact with minors. All right.
Thank you very much.
Anything else?
No, Your Honor.
All right, thank you. And are you Mr. Evans?
Yes, ma'am.
All right, in each of the cause numbers, the court has received a motion to amend bond conditions. State, have you had a chance to review the motions?
Yes, sir.
State, are you prepared to proceed?
Yes, sir.
So it appears that his conditions are GPS, full house arrest, and no contact with the complainant. And is the complainant the same in each cause number?
To answer your question, yes, Your Honor.
All right.
If I may, I believe he's on partial house arrest at this time, Judge. He's allowed to go from
It's tracking.
his tracking.
Okay, well, I'm just saying, because that's what it says in your motion.
What date was that motion filed, Your Honor?
This is November. Do you have an updated one? All right, if you could give me a copy of the updated one.
And Judge, it was modified in January.
All right, thank you.
I'm going to hand you motions.
All right, thank you. I appreciate that.
Those should be file stamped on February the 6th, the last
Yes.
court date. We also have included motions for speedy trial in both cases.
All right.
Assertion of the right to a speedy trial.
All right, so first things first. So there's a partial GPS for work only, and there's no contact with the complainant.
Correct.
So defense, what are you requesting?
We're requesting the removal of the GPS altogether, Your Honor. My client works at Specs as a delivery driver, and
Mhm.
it's impossible for him to go all around. Well, excuse me, not possible. He did work that route. Mr.
Yeah.
Evans, would you like to explain better than me?
Yes.
Oh, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larry Evans.
All right.
Mr. Evans, where do you work?
And Specs.
What do you do at Specs?
Delivered liquor.
So when you deliver that, you go all around the city, correct?
Yes.
And when you do that, you originally had a problem
Yeah.
with, when you originally doing it with GPS tracking.
Yes.
And then what happened?
I was with some clients and it went off. And so my supervisor said, since it went off, I can't work the route until I get it removed.
and it takes 2 hours from my
Hold on.
10-hour day.
So he said you can't work the route until you get it removed.
Yeah,
So they shifted you to a different
it's
position
a warehouse.
and you actually lost money based on that.
Yes,
And every day you're losing money based on that information.
yes.
And you can, I don't know if the court wants more explanation on how he's losing money, but with those 2 hours, but
Well, I want an explanation on how the fact that he's allowed to work on GPS and it went off and therefore he can't work the route. I don't understand.
do you want to explain?
Well, they said I embarrassed the clients.
Okay.
So they moved him to a position in the warehouse. We would ask that that be removed so he can go back to his original position. I apologize. I'm getting the feedback on the microphone, so it sounds like I'm loud. So Mr. Evans would ask that you remove the GPS tracking. He understands the bond conditions. He understands he needs to stay away from Miss Whitaker. However, with him losing money based on this GPS tracking and the rest of it, that's why we'd ask those to be removed at this time.
All right. State, do you have any questions?
Mr. Evans, have you had any contact with the complainant in these cases?
No more.
Have you had any contact with the family members of the complainants in these cases?
No, ma'am.
Do you, if GPS is removed, do you have any intention of contacting them in these cases?
No, ma'am.
What about the family members of the complainants?
No, ma'am.
No police action.
All right. Any other witnesses?
No, Your Honor.
All right. The court will hear argument.
Judge, he's losing money. There's no argument from the state that he has had, or has he continued to influence anyone in this case? There's no evidence that he has violated the bond conditions before this, and he has no intention of doing so after this. We are asking for a speedy trial as well for that reason.
Well, no, let's focus on the motion to amend the bond conditions, then we'll get to your speedy trial.
I understand that, Judge, but they go together insofar as that we're asking for this to go forward quickly. We're asking for this to be resolved quickly.
State, are you prepared to go to trial on this today?
Your Honor, yes.
All right. So there we go. We have your speedy trial today.
Okay, so we'd ask for the bond conditions to be removed today as well. Go ahead.
Your Honor, obviously the state will defer to the court. However, it is concerning to the state that we have an incident of June, from the end of June last year. And then we again have an incident from October 22nd of last year. That's a violation of the bond condition to have no contact with the complainant. Now, we did have the opportunity to speak with the complainant a couple of weeks ago. She did confirm that she had not been bothered by the defendant in this case since that October incident. However, we did not have the opportunity to discuss removal of a GPS with her, so we do not have her input on that, Your Honor. But the state does have concerns for that violation of the bond condition initially.
All right. And counsel, I do have concerns as well because there are two cases.
Right,
And the case from that's ended in 0056, when is that alleged to have occurred?
0056 is the violation of protective order.
Yes.
0056, Your Honor, is the assault family second. That was an offense date of June 25th of 2023. The violation of protective order or bond condition, is 0059 with an alleged offense date of October 22nd, 2023.
All right. So I'm not inclined to remove GPS. I don't know if tracking will help him, and state if you will have any objections to tracking only.
I don't have any objection.
I'll give him tracking only, but I'm not going to remove the GPS. Yes.
On the bond condition, if I'm somewhere and somebody comes approach me and they tell me she's there and I leave and they cause the problem, I just want to know how I'm at fault. If I'm already somewhere and they follow me or find out where the party at and then I leave and her friend says I did something, how I'm at fault? I don't.
All right. It sounds to me like you're trying to give me the facts of the case as you see those. This hearing that we're having right now is not for me to determine the facts of your case and whether or not something happened or did not happen. Unless you want to do a bench trial, then of course I will hear everything. All right. So really his plea deadline date is scheduled for March 18th, but we do have a murder trial that's up first. So if something happens to the murder trial and he wants his speedy trial, we'll give you a trial today. So if y'all still want a jury trial today, we will give that to you. Otherwise, your plea deadline date is March 18th.
Do you want to have the plea deadline date as March 18th, or do you want to be on call for today, Mr. Evans?
It's up to you. Otherwise, you're due back here on March 18th. So we potentially could give you a jury trial today, or either you can come back on March 18th. Which do you prefer, Mr. Evans?
March 18th.
I'm sorry?
March 18th.
All right. So do you still want to assert your right to speedy trial counsel? Because your client is saying that he prefers to come back on March 18th.
I'll defer to my client.
All right. Are you withdrawing your motion for a speedy trial?
This time, Judge, we would ask for the trial date of March 18th.
Well, March 18th will be your plea deadline date. All right.
We would be
So,
ready for trial on that date as well.
all right. So are you withdrawing your motion for a speedy trial?
Yes.
All right. Is there anything else? All right. We'll see you back on March 18th.
Thank you, Your Honor.
You're welcome. All right. And it appears you have issues with marijuana. Can I see the file on Mr. Gobert? Thank you. So you're on probation
Yes, ma'am.
for robbery.
Yes, ma'am.
Do you know how much time you're looking at if you were revoked?
I'm not sure.
All right, so let me tell you, just deferred adjudication. So you're looking at 20 years if you were revoked. So the question for you is whether or not you think smoking marijuana or giving me dilute UAs is worth a potential of 20 years in prison. What do you think?
No, ma'am, it's not worth it.
So why do you keep using?
I'm just diagnosed with anxiety and depression. Sometimes it's the only thing that helps sometimes.
Well, you need to have a doctor for that. Do you understand?
Yes, ma'am.
So I'm going to have them test you for levels and probation.
Yes, Your
Mr. Gobert, can you see if he's, have him evaluated for MIC? All right, we'll see if he's able to go back on the MIC unit. And I'm going to want him tested for levels. Okay. So they're going to test you for levels. If you have a problem with depression or whatever your problem may be, now's the time to speak with probation so they can help you address that. Do you understand?
I do take medication for anxiety and depression.
All right, well, you're not allowed to use marijuana while you're on
Yes, ma'am.
probation. You understand?
Yes, ma'am.
All right, so I'm going to have you speak with probation, okay?
Yes, ma'am.
Thank you. Who's here on Jonathan Santabella? Did he plead? And misdemeanor court? Listed as
Well, I think that I'm supposed to be lead counsel with him, and somehow I have to check and see what's going on with that. So,
all right, so if he's on the system and you're not, it shows that he's on the system.
yeah, but he's on it. We're co-counsel on it.
Well,
So-
no, he would have been notified.
No, Norma checked. He wasn't notified.
Well,
And
here's
his
the
office
thing.
checked.
This was set for August 20th, and there was a no-show by the defense attorney and Mr. Gobert.
Yep, and Norma checked.
Okay, so let me finish speaking.
Okay.
All right, everybody, take a breath. Calm down. Let me finish speaking. So he was set on August 20th, and the court is aware that sometimes there's some issues with the system. And your attorney listed on the system is Daniel Vela. She's not listed on the system as your attorney. Now, whether she's second chair, their co-counsel, doesn't matter. If she's not in the system, she's not going to get notice. No, stop. The only person who's going to get notice is the person who's on the system. I will tell you who Daniel is. Daniel, she said, is her co-counsel on this case, and he's the person who's listed. So if you don't know Daniel, then you probably should introduce yourself, or he shouldn't be listed on the system. So this was scheduled on August 20th. Because there have been issues with the system, I don't immediately issue a bond forfeiture because maybe somebody didn't get notice. So Ms. Ferguson will send out an email or contact or text the attorney. So that's why this case was set on August 20th, and I didn't do anything. But what I wrote on the docket sheet is recalled for August 22nd, 2024, and I have no show, defense attorney and defendant. And then I put no notice in the system. So That is why we're here today. So who's the prosecutor on Gabriel Maurice Gobert? All right. State, is all of the discovery uploaded? All right. Have you checked to see if any discovery is uploaded? All right. Are you able to look and see if the discovery is uploaded? Do you need the cost number?
I will need the JN. If you give me a moment to log in.
What I can tell you is I don't have access to the JN number, I don't think.
You want me to look it up?
Yes, please.
It is 212
Just 1 second. He's logging in.
212
9226.
As I explained, the way that the bottom is done, we got out on this.
No, Your Honor, I have not conferred about discovery with Ms. Wetland, so I don't know if there are any items missing that, in her opinion, should be.
All right. So here's my question. What you're looking at, does it show where you have uploaded items?
Yes, Your Honor.
All right. So Ms. Ferguson, set this for discovery in 30 days. And by that time, when you all come back, everybody needs to be prepared to sign an acknowledgement of discovery. What date? All right. And Ms. Ferguson, is Ms. Whitland now listed as his attorney or no?
But it was never, I guess, converted over.
Yeah. All right. So we need to make sure that she's on there. What is this?
Yeah, because see, the system's all messed up. Yeah, I should be on there as lead counsel.
Well, I mean, you're not on there, but what I do know is Daniel Vela is listed. You don't know who he is. I understand. She's saying that's her co-counsel. So who is lead, who is second, doesn't really matter. He's listed on there. And if she wants to be listed as lead counsel, then it needs to be put in the system that she's lead counsel. And the only way it can be put in the system that she's lead counsel is if she files a notice and puts on there that she's lead counsel.
Which I did.
All right. All right. Thank you. Norma, give them the reset form for September 23rd and make sure both parties sign it. Thank you. All right. Court is calling 2020 CR 2127 State of Texas versus Gabriel Maurice Gobert. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Carolyn Wendler for the defendant, Your Honor.
And are you Gabriel Maurice Gobert?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am. You didn't review that?
This is the one that we've had before. This one is here. This is the one that they give. You've seen the copies of. Handle with that.
Okay. Oh, yeah.
All right. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Gabriel Maurice Gobert who was placed on deferred adjudication in 2020 CR 2127 for the offense of robbery on December 15, 2020 for a term of 5 years? Is that you?
Yes, ma'am.
All right. State.
Your Honor, I believe the defense was going to ask for a contested date.
Yeah, I am judge, but I also I have to highly consider if I need to do a competency. That is also like something that I am debating.
Okay, so this is what I don't understand. And I want you all to clear this up for the court. We were here in August for a contested on August 31st. Then you all asked for it to be removed to September 14th. And then we are here. We were supposed to be here on October 19th, then October 26th, and now we're here on November 6th.
I can
explain this to me.
I can speak to it probably a little better, Judge, because I've been here for all the settings. Initially, I think we thought we were going to have an agreement. And then we have not come to that agreement. The last setting that this was set, the state actually had thought they were going to supplement the MTR I think that that was the last setting. That's why the court reset it for now. Part of the long reset had to do with I had surgery and then we came back and I think we had approached and we thought we were all going to be have a good plan, but we still don't have a good plan in place.
Right, so here's the plan.
That's where we are.
This is being set for a contested hearing. Do not get into any plea bargain agreements because this is going to be a contested hearing. That's the plan. Ms. Ferguson, give me a date for a contested hearing.
We can come back on the 16th. Is that enough time?
Well, Judge, the only thing is, as the court, when the court asked my client, has he seen this? Does he understand? I struggle and I'm not sure that Mr. Goldberg does understand. So I'm going to talk to my mother a little bit about the possibility of having to get him comped. But
if you go and ask for competency, they will do it one fast in a hurry.
Well, that may be what I need to do, Judge, just to make sure that he understands what's going on. I think that is.
That needs to be done, and we're coming back on November 16th for a contested hearing. What time is Ferguson? All right, 9 a.m. It's contested. It will be contested. It's not going to be anything else but contested. And if you'll go down to Judge Carruthers and Ms. Ferguson, if you'll send Judge Carruthers an email and let him know to expedite this competency.
Yes, ma'am.
Is there anything else?
Nothing from the defense, Your Honor.
There will be no further resets in this case.
Thank you, Judge.
Thank you, Judge.
Welcome. And State, is this still going to be a contested?
I haven't had a chance to talk to Mr. Whitman about it.
Okay.
So I don't know, Judge, exactly. I think that, let me think, I don't believe it is. If I saw the MTR, I don't believe it will be.
Okay.
I think our inclination is we don't have the drug report back yet, Judge. Maybe. Right. We don't have the drug report back yet, and since we're being pushed to a contested, there's kind of a withdrawal.
Okay.
And wait for that to be indicted, and then once it's indicted, then proceed appropriately from there.
All right. Are there any conditions you want added?
I mean, the only thing that I would suggest is that, I mean, since the charge that is coming forth, if it is it is drug related, we'd be requesting, weekly UAs and weekly reporting.
All right. So they're going to withdraw the motion. I'm going to alter the main conditions to include the UA hotline. And then I think the UA hotline will take care of the weekly reporting. So the UA hotline, and it needs to where he tests at least once a week. Is there going to be anything in your system?
I've been still trying to get marijuana out of my system, so
all right.
The level should still be going down.
All right, they're going to test you for levels, okay? All right, so that's all. You can speak with probation and they'll tell you everything, okay?
Okay.
All right, you're welcome.
Say to Judge, sorry.
Oh, no problem.
I decided yesterday.
She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge. Right.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler. Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the license plate, think that what is the traveling by right is what I think how they term it. You know,
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
but he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally.
Remember, this is just a mere probable cause.
Yes,
So,
I agree.
you know, they ask you to come out of the car one time. Yeah, you know, it's really, that's, so, I mean, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, you know, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberl?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration. We have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police, so I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration, number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case where about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
No, right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake,
Thank
I'll
you.
reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy.
I mean, I think the case is only 3 months old.
Yes.
So you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. You know, really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over.
Good morning. I'm Judge Chungan. We are here on people of the city of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant today we have, please.
James Kazicki. I'm the House Counsel. I spoke with Mr. Crane, had a breakdown in communications. I don't believe I can go forward representing him. We do not, support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. I explained that the rights that you have.
Well, I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Kazicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. Okay, sir. So in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines can be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So you're going to meet with an attorney here in the court. Write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, they can't be sent to jail for these. They're simply not criminal offenses. All right. You'll be fined up to $100 on each of those, but you can't be sent to jail. But just for your information, they are accompanying charges. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again. You come back on July 16th in court for a pretrial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part. But what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.